Despite the disappointing ruling, these powerful, country-saving, it's saving our country, the kind of money we're taking in, peace-protecting. Many of the wars I settled was because of the threat of tariffs. I wouldn't have been able to settle them without. Will remain in place under fully approved and tested alternative legal statutes. And they have been tested for a long time. They're a little more complex, but they're actually probably better, leading to a solution that will be even stronger than before. Congressional action will not be necessary. It's already time-tested and approved.
Something happened at the State of the Union address that legal scholars and constitutional experts are saying may be remembered as the moment when this country's slide toward a full constitutional crisis stopped being theoretical and became visible to everyone watching. Not in the shouting, not in the empty seats, not in the theater of the evening's political performance, in a single sentence, delivered from the podium, by a president staring down at the Supreme Court justices sitting in the front row of the chamber he was addressing. Congressional action will not be necessary. 5 words, packed with a meaning that every constitutional law professor in America immediately understood, and that the mainstream coverage of the speech almost entirely buried beneath the noise of everything else that happened that night. The Supreme Court had just ruled that his tariff authority was unconstitutional, that the power to impose tariffs belongs to Congress under Article 1 of the Constitution, that he had exceeded what the law permits, and his response, delivered publicly on camera to the nation, with the justices who issued that ruling sitting directly in front of him, was to announce that he had found other legal mechanisms to accomplish the same thing and that Congress would not be needed. Make sure you're subscribed to The John Brown Show, because what that sentence represents is not a policy announcement or a legal strategy update. It is a president publicly declaring that a Supreme Court ruling will not actually constrain what he does. And the people who spend their professional lives studying what happens when presidents say things like that are using a specific phrase to describe where this leads. Constitutional crisis. Not approaching, not possible, coming. Here is what a recently retired federal judge who has dedicated his post-bench career to educating Americans about judicial independence just said about this moment. He was asked directly whether what we are witnessing represents a threat to the system of checks and balances that the Constitution established. His answer was not reassuring. He said, "We have been approaching Rubicons throughout this administration's second term. The politicization of the military, the weaponization of the judiciary, but the ultimate Rubicon, the one that transforms everything that came before it from concerning to catastrophic, will be when the president openly and brazenly defies a ruling by the Supreme Court." And he said that moment is coming. Share this video because the visual that accompanied that State of the Union moment tells the story more completely than any legal analysis can. A president at a podium, looking down, literally and physically looking down at the Supreme Court justices whose authority he was in that moment publicly dismissing. The people who ruled that his tariff policy was unconstitutional were sitting in the front row of the chamber while he announced he had found ways around their ruling and that Congress, the institution the Constitution vests with tariff authority, would not be involved. That is not a president engaging with a legal setback and working within constitutional limits to find a new approach. That is a president performing contempt for the branch of government that checked his power in front of the nation that branch exists to protect. Think about the specific dynamic that creates for the justices in that room. Several of them were appointed by this president. They were placed on the court by the man now publicly declaring their rulings insufficient obstacles to his agenda. They owe their lifetime appointments to him, and they are watching him announce from the podium that he has already identified legal mechanisms to accomplish what they just told him the Constitution does not permit him to accomplish unilaterally. Make sure you're subscribed because the Reuters data that emerged alongside this constitutional confrontation reveals that the pattern of court defiance is not theoretical. It is already happening at scale. Over 4,400 illegal detentions documented, 89 violations of specific court orders. Those are not allegations from political opponents. Those are documented figures reflecting actual cases where federal courts issued orders and the executive branch ignored them. where judges said release this person and the person was not released, where judges said do not transfer this detainee and the detainee was transferred anyway, where courts established clear legal requirements and the agency with the power to comply chose not to. A retired federal judge sitting with legal scholars and jurists wrestling with exactly this question said something that every American needs to hear. He said the judiciary is the weakest branch. Alexander Hamilton said it in the Federalist Papers. The courts have neither the power of the purse nor the sword. They cannot tax. They cannot command armies. They cannot send law enforcement officers to enforce their own orders. Their only real source of power is the public trust. The belief shared by enough Americans that court orders represent legitimate legal authority that should be obeyed. When an administration decides systematically that court orders are obstacles to be managed rather than authority to be obeyed, that trust is the only thing standing between a functioning constitutional system and something else entirely. Share this video because the question of what happens when that trust erodes is one that constitutional scholars have studied extensively, and the historical precedents are not comforting. There is an old quote attributed to Andrew Jackson about a Supreme Court ruling he disagreed with. The court has made its decision. Now let them enforce it. Whether he said it in exactly those words or not, the sentiment is documented and the historical moment it describes is instructive. The court ruled. The president disagreed. The president understood that without an enforcement mechanism of its own, the court's ruling was only as powerful as the executive branch's willingness to comply with it. The retired judge who discussed this question directly said that what we have thus far not seen is an example of the Supreme Court conclusively ruling on the merits of a case and having that ruling openly disregarded. That moment, he said, has not arrived yet. But the trajectory of this administration's relationship with judicial authority, the 89 documented court order violations, the 4,400 illegal detentions, the State of the Union announcement that the tariff ruling would be circumvented through alternative mechanisms is pointing directly toward that moment. Think about what changes on the day that moment arrives, not just legally, institutionally. Every subsequent court order issued by any court in the country becomes subject to the question of whether this administration will comply with it. Every case involving executive power becomes a test of whether the constitutional framework that has governed American democracy for 2.5 centuries actually constrains this president or merely inconveniences him. Make sure you're subscribed because the dismissal of the military's Judge Advocate General Corps adds a dimension to this constitutional confrontation that the judge who discussed it found particularly alarming. The JAG Corps is the conscience of the military. These are the lawyers who advise combat commanders when they are about to give or receive an order that might cross a legal line, who tell generals what they can and cannot do under the laws of war, under the Constitution, under the legal frameworks that distinguish a military operating under civilian constitutional authority from something else. The Secretary of Defense's first significant action was to dismiss the career JAGs who had been performing that function and replace them with new personnel. The retired judge who served as an Army JAG himself did not minimize what that means. He said there may be a time when we find out whether the legal advice given by the new military JAGs is faithful to what that mission has always been. He said the scenario that concerns him most is American troops in American cities because they have been ordered to be there, and a platoon commander turning to a JAG and asking whether a given order is legal and what answer that JAG gives. You dismiss the career lawyers who have spent their professional lives developing the institutional knowledge and the professional independence to say no when the answer is no. You replace them with new lawyers who have not yet established that record, and then you wait to see whether the advice they give when the moment arrives is the advice that the Constitution requires or the advice that the commander ordering the action wants to receive. Share this video because the public education problem the judge described is the foundation on which everything else depends. Most Americans do not think about judicial independence in their daily lives. When they hear the phrase judicial independence, they do not hear a description of the structural mechanism that allows a person of ordinary means to stand in the same court as a powerful, well-financed opponent and have a realistic chance of receiving a ruling based on the law rather than the relative power of the parties, they hear something abstract, something institutional, something that sounds like it might mean judges do whatever they want without accountability. The retired judge said this public perception gap is one of the most dangerous vulnerabilities in the current moment, because when a president attacks judges publicly, calls their rulings disappointing, calls them a disgrace to their families, suggests without evidence that they might be under foreign influence, and then announces at the State of the Union that he has found ways around their rulings, the people who do not understand what judicial independence actually protects cannot provide the political resistance that would make those attacks costly. But when you explain it differently, when you describe a family facing foreclosure, going to court, and having a judge rule that the bank did not follow the law, not because the judge felt sorry for the family, but because the bank actually did not follow the law. When you describe an injured worker going to court against a corporation with 100 lawyers and winning because the facts and law supported them. When you describe what courts actually do for ordinary people in ordinary situations every day, the abstraction becomes concrete and the threat to that system becomes something people can feel. Think about what a court system looks like when judges factor in who might be offended by their rulings before they issue them. When federal judges consider whether ruling against the government will produce public attacks from the president before deciding whether the government's position is legally supportable. When the independence that allows a judge to rule against power is replaced by the calculation of what ruling against power will cost. Make sure you're subscribed because the constitutional moment we are in right now is one that requires the American public to understand what is at stake before the final line is crossed rather than after. The judge said that when the moment of open Supreme Court defiance arrives, the public itself will need to come to see the danger of that happening. That is the ultimate check, not the courts themselves, not Congress. The American people understanding clearly enough what judicial independence means for their own lives, that they provide the political resistance that makes defiance of court authority institutionally and electorally catastrophic for whoever does it. That public understanding is being built right now in the gap between what this administration is doing and what the Constitution permits it to do. In the 4,400 illegal detentions, in the 89 court order violations, in the State of the Union sentence that told the nation congressional action will not be necessary, in the retired judges and legal scholars and JAG veterans who are dedicating their post-service careers to explaining to Americans what the judiciary actually does for them and why an administration that treats court orders as obstacles is threatening something that every ordinary American depends on. The Rubicon has not been crossed yet. The final order that openly defies a Supreme Court ruling conclusively decided on the merits has not been issued. But a president stared down at the justices who checked his power and told the nation he had already found another way. The warning light is flashing. This story is just getting started. Stay tuned.